We've actually had 5 of these in a relatively short amount of time. So thank you for your continued attendance and interest. Again, Mo Wright with RAMA, serving as facilitator for today. So we're going to jump in pretty quickly, as we do have a pretty lengthy agenda and want to make sure we get some time for you all to weigh in on a number of items during the course of today's conversation. You should have gotten the agenda in advance, but just to recap that, here's a brief synopsis of what we'll be doing today. So after some initial opening stuff, we're going to go back into more of the specifics around the collective bargaining. We spent the end of the last meeting talking from a more universal perspective around collective bargaining. What is it? How did it come to be? Why is it important? Those aspects. Today, we want to continue with Jenny, moving the conversation into what the negotiation process will be with the FOP for the next contract, some rules around that, and then certainly she'll probably weigh into some of the implications of some of the things that the CRB would be asking for. And without going into strategy, right, this is a public meeting, but certainly able to talk about how that process will likely unfold and where we will probably see some points of disagreement between both parties. And so we'll get all into that at the first part of our meeting, as well as some of the contract elements. We are leaving some time for you to be able to ask questions throughout that conversation, because we do want you to understand what will be maybe non-starters, or at least may be very difficult to accomplish, as well as some of those kind of common negotiating elements that are a part of the process. I'll let Jenny go through all of that. The second part of our conversation today, during your open forum, will facilitate discussion around, we also are in budget season for the city. And as we know, a big part, the most significant part of the city budget is that of public safety. And so while there are some longer term things we'll be talking about from the bargaining perspective, there are certainly some short-term opportunities that the current budget process does afford us. And so we want to certainly hear from this group about ways in which we might prioritize existing budget items within the existing budget infrastructure. And this is the time of year when the city is putting those budgets together. And so I want to hear from you around ways to think differently about the public safety budget and have you to weigh into that process. So we're going to have a brief presentation, first of all, so you understand the big picture mechanics of the budget, and then we'll open the conversation up for you to talk about some ways in which you might help us to think about prioritizing things within the public safety budget within the city. And that should probably put us right at the end of the meeting today. We'll leave some time at the end, hopefully, for some general question and answer, but certainly want you to be engaged along the way. So again, welcome back to everyone. As we always do, we do want to start with a few reminders, and I think the first is just kind of going back to our charge we talked about at the beginning of this process. The city asked you to be a part of this work group. You graciously said yes. So Matt, I'm going to allow you to talk a little bit about that charge and what this group's been asked to do and what the charge of the group is moving through this process.
Thanks, Mo. And again, just like Mo said, we just kind of want to recenter, make sure we're still focused. Our charge really is in 2 parts. The first part really mirrors the language that is in the charter amendment. So you can kind of see how similar this work is. The work group is charged to make recommendations, and not to read to you, but to establish an independent civilian review board to investigate officer misconduct, recommend discipline, and provides for civilian oversight and accountability of Columbus Division of Police based on national best practices and community expectations. So the second part is really kind of outlines more specifically what the mayor wanted the work group to do. You shall examine similar boards and make recommendations on, among other things, how the board will be seated and structured, so a lot of things we've already talked about, and the policies, procedures, and funding necessary to accomplish its mission. So again, the first part, I think, really reflects what the charter amendment says. If anybody wants to look at the charter amendment again, all of the information that we have, every presentation that Mo uses and our presenters use, all the reports that we provide for you is available on the work group site. And I do urge you once in a while to go back and maybe look at some of those things, maybe to refresh your mind on some of the things perhaps we've already discussed and kind of where we're going. So does anybody have any questions on the charge or our next steps or what we're doing? Okay, thank you. I'll turn it back to you, Mo.
Thanks, Matt. Appreciate that reminder. Just another reminder would be that we are in an open meeting format. Just know that your comments are being recorded and both streamed to the general public, and the record is being made public via video. Remind you that we will not use the chat feature, so we can keep those conversations in the public. So make your comments orally as you deliberate and weigh into the conversation for today. With that, Brandon from our team has kind of been our consistent note taker and has been the person who has provided the summary of the meeting. So Brandon, and those all get posted to the website, but Brandon, if you can just hit the highlights maybe of meeting 4 and just kind of recap where we've been, and then I'll jump into the conversation for today.
Yeah, for sure. So on our last meeting, it really was, the big part of it was a foundational overview of the suggestions thus far from work group members. That include the roles and responsibilities of what the CRB should be, as well as including the CRB term limits, board member selection, and functionality of the CRB. There was a lot of conversation and discussion around those things, but there still needs to be a level of clarity and final decisions made, specifically around the term member limits selection process, as well as the decisions. After that, we also had a discussion around the oversight functions checklist, comparing some of those actions and powers to other similar cities, and then looking at what Columbus actually would want. There was some decisions made on some of those powers, but there still needs to be some clarity around a couple of those as well. Following that, Jennifer Edwards from Baker Hotseller gave an overview of the collective bargaining process, kind of level setting the whole group on what that bargaining process will look like, and that will be continued on today. And those were pretty much the big topics that were discussed in last meeting.
Thanks, Brandon. And so we'll really pick up today's conversation there. As I said, first kind of continuing the conversation and understanding around collective bargaining, but much more specific today to the next round of negotiations, and then how our deliberations around the CRB and Inspector General will weigh into that process. But there's still some additional context we believe you need as a part of that. So I'll ask you to certainly listen up and learn as much as we can, but then also to ask Jenny any hard questions that she might be able to answer for you. And to the extent that we don't have an answer or can't answer today, we certainly can make note and follow up as needed in that process. So with that, I'm going to turn it over to Jenny. I think she's going to share screen from here, and we'll be back to talk a little bit on the other side about some of the things that came out of this particular conversation and presentation. Jenny?
Thanks, Mo. And thanks for having me again. I appreciate the opportunity to continue to converse with you all about this and help you kind of orient to the process that will be necessary for you to effectuate the change you're looking for. There were a couple questions from last time I wanted to address very briefly so that we can get into the content for today. One question last time was about decertification. There's a lot of rules around this, but from a big picture standpoint, the question was what would happen or how it would be possible for the union to no longer represent the employees within the bargaining unit. Decertification, again, big picture, requires an employee or a group of employees to file a petition for a decertification election with SERB. That's a state employee relations board. SERB then investigates to determine if there's reasonable cause to believe a question of representation exists. There is a process through which information is exchanged between the parties, an election is held, and in order for a decertification to be effective, it would require more than 50% of the total number of valid ballots that were cast by employees to vote against that continued representation. There are some rules. For example, an employer cannot pressure employees to decertify a union. That gets into the unfair labor practice space. And there's lots of rules and regulations around that, but that's the general concept I wanted to make sure to follow up with you on. We also had a question about CERB's credentials for fact finders and conciliators. There is a list of credentials on CERB's website. I'll give you again some kind of high level points. The candidates have to complete an application, submit 3 writing samples, submit 3 references, including a representative from a management position, as well as a union representative and a neutral. So an arbitrator, fact finder, conciliator also has to submit one. They have to be a resident of Ohio or an adjoining state to be a fact finder, resident of Ohio to be a conciliator, cannot be an advocate, so cannot be a current lawyer who advocates, or an elected office holder. They have to have experience with labor relations and the revised code, a demonstrated knowledge of governmental structures, processes, public finance, compliance with codes of responsibility. They have to produce well-written reports, be impartial, and be acceptable to the parties. So that was question number 2. And then the third question I wanted to address before diving into the collective bargaining process, there was a question about employee pensions, and those are vested contributions. So the employee is taking money that they earned and contributing that to their own pensions, as is the city. It's considered in some ways a contribution related to their wages. So it's vested, and therefore it is an employee may no longer have the right to contribute and may have their funds refunded to them or paid back to them upon termination, but they're vested contributions that would not be removed later or taken away from them. So let's hop into, I wanted to do a quick recap of fact finding and conciliation process, and then we'll talk about what that process looked like during the last round of negotiations, and then some high level points about some of the powers I heard you talk about last week and where the collective bargaining agreement as it currently stands may be implicated. That way you'll have a sense of what sort of bargaining would be required to make changes, and in all honesty, the actual likelihood of achieving some of those changes either now or in the course of several rounds of bargaining. So remember that for fact finding and conciliation, the parties are going to present evidence regarding their proposals. In the fact finding context, the fact finder is going to issue recommendations. Those are non-binding. They are suggestions to the parties, and those recommendations can be accepted or rejected. When the fact finder is considering recommendations, he or she is going to think about the past collective bargaining agreements between the parties, comparable data, so people doing the same jobs for other public employers. Typically, they will look at both public employers who have the same size of bargaining unit and or in the same region. So we frequently look at the big cities in Ohio and also the surrounding suburbs of the city of Columbus to kind of help the fact finder determine what would be reasonable. The fact finder will also consider the interests and welfare of the public, the ability of the employer to finance and administer the proposals, which we'll come back to throughout today, and the effect of proposals on the normal standard of public service. They'll look at the lawful authority of the public employer, any stipulations of the parties, and whatever else they find to be persuasive. To mention, once the fact finder makes those recommendations, and if they are rejected by one of the parties, then the parties are going to go straight to conciliation. Conciliation is similar to fact finding. You're going to use similar evidence, similar witnesses. The difference is the conciliator picks one of the parties' sides as to each issue. And the second piece, the second big difference is that the conciliator's decision is binding. So the parties are stuck with the conciliator's choice, and that means taking the language directly out of the conciliator's decision and placing that into the collective bargaining agreement as is, unless the parties negotiate something different. So I have seen it where a conciliator, despite being very well intentioned and very bright, might put together language that is not ideal from either party's perspective, and that can put us into a place where now we're doing some additional negotiation. And critically, because that's what happens, it's binding, and now we're taking that language and we're putting it into the contract. It makes the rejection of the fact finder's report risky. So when the fact finder comes out and says, hey, here's what I recommend. I recommend a 2% wage increase. The city is in the position of having to think about, okay, maybe we went into fact finding recommend with a 1% proposal, and the FOP or another union went into fact finding with a 5% proposal. If the fact finder here kind of split the baby and said 2%, is that better than taking the risk of a conciliator instead saying we want it to be 5%? And the city then being bound to accept that proposal and move forward with it. It's easy to use that. It's easier to use the financial proposals as examples because it's 1% or 2%. But you can imagine that as we get into some of these more complicated proposals about authority and investigations and discipline, that there's even greater risk in some way because just one or two word choices different from a conciliator can really put a significant burden on the city that it's not necessarily anticipating. So we can see a really it's a really risky thing to do to go to conciliation in most circumstances, especially when there are substantive issues like you all are considering now. Remember that conciliation exists because our safety services are not able to strike, which is why that there was that emphasis on at some point somebody has to make a decision. We're going to have a third party make a decision if the parties can't agree, and that third party neutral is going to be able to just put it into the contract so we can all move forward. So let's talk a little bit about the negotiation process and what that looks like practically. And we'll use the last round as an example, although we don't know really at this point exactly what the negotiation process will look like because we haven't gone to the table yet. The last round, the chief negotiators were Ron Linville from Baker, he's my law partner, and Mark Fester, who is a sergeant with the city and the grievance chair for FOP Lodge 9. Those will be the same two lead negotiators for this round of bargaining. Other members of the city's bargaining team and key players in the negotiations are the human resources, citywide human resources, especially the labor relations team. There's also human resources from CPD, obviously public safety is there, finance and management, and employee benefits, because a lot of the negotiations tend to center around insurance as well. The prior CBA was set to expire December 8th of 2017. That year we did what we had done, generally speaking, in the past. And that was that we went to negotiations in September of 2017. The bargaining teams met on 22 occasions. So 22 meetings, generally in the range of 4 to 12 hours long. And the parties executed continuous extensions and operated under the expired CBA for nearly 1 year. I did see that maybe somebody had a question. You are welcome to ask questions of me at any time. I'd rather we be interactive than
yeah.
not.
I just
Go ahead.
Mo, I don't want to mess up your flow, so I'm just asking, like, would you like me to hold them to the end, or do you want to ask questions as we go?
No, we built in this time to allow for the questions along the way, and I think it's better for Jenny anyway. So yeah, go ahead.
Okay.
If you have them now.
I have a lot of questions. I'm sorry. Can we see what proof has been presented in past negotiations so that we can get a feel for what has the city been asking of the police, what evidence has been presented, and what arguments have been found to be solid? And then are this conciliation thing, if it's so dangerous to go to conciliation, that says to me that these people are not neutral. So who are these people that do is this appointed by the State Employment Relations Board? Like, do we know, like, is there ever a minority in the room when this happens? Like, what is the makeup of the conversations that are happening? Right? Is it a bunch of people that don't live in Columbus, that don't look like the people affected, sitting at the table arguing for these things? Or is there like some sort of representation at the table?
That's a good question. They are neutral, but they are not. So let's kind of go back. One, I think we could get you both the last fact-finding award as well as the post-hearing brief, which would reference those briefs, which reference the exhibits that were relied on by both parties. I will share with you that the city's brief last time was 98 pages long, and the union's brief was 80 pages long. There were a lot of issues, and I'll kind of come back to some of that so that to kind of walk through with you the why. Like if you hang tight with me on that, we'll talk through kind of what all was at issue last time. But when we look at the neutrals, they are in fact neutral. They are not parties, and again, CERB appointed, so they have to go through the process with CERB. And then CERB will give us that list of people that we try to choose from based on who maybe sometimes rules in favor of employers as compared to someone who rules in favor generally with unions on a particular issue. We try to kind of weigh all that out. The representation in the room is the city administration and CPD. So as far as the city's priorities, that's why having this sort of work group is really valuable, because we take our direction from the mayor and the administration. So to the extent that you are making recommendations to the mayor, you are represented as we put those together and make proposals that are consistent with those recommendations. In the room, it is confidential what happens in the room, at least as far as the negotiations process. When we're actually kind of going back and forth, that's confidential. The fact-finding hearings are confidential, but the documents that we're using and submitting are not confidential. Those are public records. At the time that we're in a hearing, those become public records. So you will have the opportunity, you can certainly see through those prior briefs the kind of what we were arguing and what our priorities were in some ways there. Then that actually brings up a great point, because I wanted to talk about who drives negotiations within the city's structure, and that is the mayor. City council will approve, has to vote to approve a final agreement, whether that's an agreement that we have tentatively agreed to with the FOP, whether it's city council that votes on a fact-finding award and decides whether to accept or reject. And it's city council doesn't really have anything necessarily to do if we were to receive a conciliation award. But the mayor drives the negotiations and sets a priority, I'm sure in consultation with city council. I'm sure understanding what city council's priorities are. We don't want to be in a position, any of us, where there's a different differing opinions about whether a fact-finding agreement is a good agreement, or I'm sorry, fact-finding recommendation is good, or whether we would want to accept or reject. So everyone's trying to make sure we're following the same path throughout the process, but in the end, it's the mayor who's responsible for the negotiations and the city council who chooses to accept or reject an agreement in whatever form it comes to them. When we think about what is the role of a third party in this, so the fact finder or the conciliator, they're looking at the contract as a whole. And remember, they're always thinking about that history from, however many decades this agreement has been in place. And so there isn't a neutral, it's not like we're starting from a brand new place where there isn't a history of bargaining between the parties. They're neutral as to what is going to change within the agreement. So there's always an assumption, and maybe this is something I could have covered more clearly last time. Current contract language, the language as it is now, is generally considered, that's the status quo, that's the default position. And everyone is attempting to change the language as it is now in the direction, towards their benefit. So we're not neutral, like starting as if there's never been a discussion. We're neutral as though these parties have been married for decades. And now we're, decades into this discussion. And from there, are we going to stay with where things are currently? Or are we going to make progress? Are we going to move one way or the other? Understandably, an employee group is typically saying, yeah, we want to move, and we want to move so that we're making more money and we have better benefits, and it's easier for us to get time off, for example. Those are all pretty regular proposals. And employers frequently are looking at things and saying, based as compared to the status quo, as compared to what's in the contract right now. For example, we might want to make changes as to how investigations are conducted. We want to be able to hold people accountable more easily. We want to save money on certain types of benefits or wages. So everybody is coming from that neutral spot of decades of marriage to one another, and then having to kind of propose that there's going to be a change. And when a neutral or a fact finder or conciliator is looking at that, what we hear from them is, look, if it's too much, if it's too controversial, if in controversial meaning I don't think it's going to work based on the way the parties have proposed it, or I just think this is too much change in one agreement and I thought 3 changes was enough and we didn't need to do 12. Again, when we're thinking fact finding, then the fact finder is going to say, I'm going to sit with status quo. I'm not going to shake it up in this way. When we get to conciliation, they have no choice but to shake up what is put in front of them and pick on an issue by issue basis, either the city's position or the union's position. I'll pause a minute.
Neutral in the fact of like, if we have a department that has systematically shown to have racism in it, and we're going to the table to ask for changes that are in the public interest, in the public good. I saw those words in the charter, and they're consistently siding with the FOP. That to me does not say neutral. I guess the outcomes to me are not neutral. Maybe they're considering the process to be neutral, but I don't see how we come to the end where we're like, can't even get police officers to take a drug test immediately after they fire their service weapon. Like, we can't get that in a contract. Like, if that's controversial, then I don't think these people are neutral. Not that you have anything to do with that. I know you can't control that, but
thank you. I appreciate that recognition.
I think it's frustrating when you have disparate impact and then people are saying that like this process is neutral, and it doesn't feel that way on the outside.
Well, and I would posit to you that you're coming into the conversation again decades in. And so that is from a labor relations perspective and the relationship between unions and employers. I really do talk about it as a marriage because that's what it is. It's saying we're going to contract with one another that this is how we're going to solve our problems and that we're going to be committed to each other unless or until, we wither away and die. And so once you're already in that and you're decades in, it is very difficult to try to untangle something that's been a part of that relationship for a very long time. And so I hear you, I understand where you're coming from, but I also think, if you think of any couple, who has been married for decades, trying to understand why they're fighting over, who opens the door first 20, 30, 40 years in, and it's been an issue for them from the beginning. It's never going to make sense if you're trying to jump into that argument 40 years in. And so that is the situation. You're coming into a scenario where that relationship is very well developed and expectations have been built on either side for a very long period of time. It's difficult to bring it back to, what happened when you were 20. Hang on, this would be bad. My computer wants to update right now, so that'd be fantastic. So I hear you. I think there is a challenge, but the neutrals, I think to the extent there are concerns about them, it's really through CERB that any change there would be addressed. To the extent that the topics that are considered, it doesn't feel or appear to you all to be neutral. That is also statutorily based, and it's the Ohio Revised Code. So I think when we look at these, a lot of times when we're talking about negotiations in the process, to the extent that there are frustrations about that, those statutory topics that must be considered, that's really change at the state level that's required that would allow the city to have greater flexibility in how it's coming to the table and what's being considered by the fact finders and conciliators. So let's go then kind of jump back into this kind of what happened during the last round. So as I said, the bargaining teams met 22 times and were able to knock out 21 of the 38 articles. So it is much more common to go to fact finding if you have 5 or 7 articles. Going with 17 indicated that last time the parties really had a difference of opinion about how we were going to negotiate and where we were going to make change on various fronts. And so having that much where we're almost at half of the articles open. From my perspective, you look at it and you can look at that number and say there was a lot going on, and there was an attempt at making a lot of change. And I would share with you that was on both sides of the table, that each party was attempting to make significant change. So we took those 17 articles to fact finding last time. We had 6 days of hearing. So that's August 14th, 21st, 22nd, 27th, September 11th, and October 15th. Each day of hearing, again, when you're thinking about process and what are you asking the parties to do in this situation, each day of hearing has significant numbers of people on both sides who are attempting to kind of present their case, including all of the negotiation team is sitting through the hearings. There's obviously the fact finder. We have a court reporter who's taking a transcript. You have then the advocates. So for example, a lot of times the additional people join the team to help advocate for the position once we get to a hearing level. And so it gets, I would admit, it gets costly. And it's costly both in the sense of paying fees for us, for a fact finder, for a court reporter, but also costly in the sense that you have a lot of critical decision makers for the city who are sitting at that table and preparing in advance. If you have a day of hearing, you probably have many days of preparation in advance of each of those days of hearing. So we have a lot of really critical people who are taken from their normal jobs and put in this room to help with this hearing and try to persuade this neutral party about the change we're looking for. Did I hear somebody ask a question? Okay. So in this, where we spent all of this time and came out with a decision, the goal for everyone was to avoid conciliation, because especially with that many issues at risk, you could end up with a contract that makes no sense from your side's perspective. So when we talk about the hearing, from the city's witnesses last time included the city auditor, and she talked about tax revenue and the budgeting process with respect to wages and insurance. The city's finance director, who talked about wages and insurance, and we'll talk about this insurance theme from last time in a minute. We had a budget management analyst, wages and insurance. We had someone from United Healthcare, the senior strategic account executive who came to help support the city's position on insurance. The city has an actuary from Aon that helps project insurance costs. And so she was there. And then on all of the non-economic items, which is what this group is really focusing on, we would call those non-economic items, except for certain circumstances, which again, we'll come back to. We had changes on discipline, job descriptions, drug testing, body-worn cameras that we were attempting to make changes on. And so Chief at the time, Kim Jacobs, was also a primary witness on those issues. The FOP also had consultants, a financial consultant. They looked to kind of past bargaining history between the parties by having an FOP member speak. They also had an actuarial expert. They also had an accountant. And then they had sergeants who testified as to those non-economic items where each side was attempting to make change. When we talk about, and this, Ms. Ayers, this goes to some of your questions, what kinds of evidence were we presenting? On the economic items, there are CERB reports, there was insurance market data, we had historical analysis of negotiations, we were looking at prescription medication usage and costs, but on the non-economic items, we were also looking at that historical analysis of negotiations. We had a lot of articles about police reform and talking about what opportunities for change had been identified by the community, including through the media, but also through various publications over the last few years. We looked, there was Campaign Zero had put together a significant amount of research, and we were presenting that research and showing how that demonstrated the need for change. We were looking at past arbitration decisions and ways that we thought the language was really, those decisions were interpreting the language in a way that was not a benefit to the city. And then we were looking at, generally from an internal standpoint, comparables, some some non-economic items. So for example, some changes on drug testing, we looked at internal comparables. So what was happening with AFSCME, what was happening with CWA, how had this been applied to the MCP or management employees? And then we also looked at what we would call external comparables or comparables. And that's where we look at other collective bargaining agreements, both in Ohio and then also nationally to say, in our circumstance, the FOP's CBA was out of the norm so that we could identify it as being different than others and saying we want it to be a little closer to what other folks are doing as well.
Can I go to the?
Go ahead.
I want to build on the question that was asked earlier. In that list, is the disparate impact of policies an element of the discussion and the negotiation?
So to the extent that there is evidence of disparate impact of policies, we would absolutely use that in both negotiations to support our proposals. So to say, hey, here's where there's been we've identified that there's a disparate impact here. It's not working, right? We need to change it. We need to change it in a way that is better for citizens, the individuals that you are sworn to protect and serve. We need it to be better for them. We would use that as a part of the discussion points across the table. And then if we ended up at a hearing, absolutely, we would use that. And that's part of where we get back to these kind of articles about police reform. So and we looked at nationally, a lot of articles related to what's happening across the country. That's where some of that Campaign Zero research came into. We also looked at locally, like what has our community been saying publicly about its perceptions and ideas and views on how policing is being done in in Central Ohio and even more specifically in Columbus, and what are they saying about this? And then we look at the language and say, well, okay, if this is viewed as impacting citizens disparately, and it specifically is related to the collective bargaining agreement, how would we want to change that language so that it has either less of a disparate impact, or we would start at least at a point of no disparate impact? This language we need changed in this way. And typically the conversation then goes from the other side, well, like, how do you know? Why? And that's where we would say, well, here's the evidence we have that there's a problem and we need to change it.
I would just add briefly here, kind of to that point and Jazz's point. I mean, to have these issues, I think being very central and open about racism and racial bias. I mean, very being specific about it too, like actually talking about racial equity and actually putting that front and center, because we cannot have this conversation in a vacuum. And so I do encourage that to be part of the conversation, even when we think about the negotiation process more broadly. Individuals have their own biases that they hold, which is going to affect the process. So it isn't a neutral process. And so as much as we want to try to make it a neutral process without having that lens around racial equity, the lens around the biases that we hold, we're going to continue to perpetuate inequality. So I encourage that instead of, even more than just, talking about police reform and these types of articles, really leaning into racial equity, the history and legacy of racism in this country, and then in our own community locally.
I agree with you that has to be part of the evidence presented. To the extent that there are concerns, again, about that kind of neutral, I'm not neutral. When I come into this, I advocate on behalf of the city, and there's nobody at the table who's confused about that. But when we're looking at a neutral third party who's going to come in and try to assess what recommendations make the most sense, perhaps some of this, again, I don't want to shift and say, oh no, you're looking in the wrong place, because the city plays a critical role in all of this. And obviously the city is the party to the contract. But if there's concerns about the neutrality of a fact finder or a conciliator, that's really directed towards CERB. And so I, would encourage this group either, outside of this, as the community advocates that you are, that is another place where we could look at and say, here's somewhere where we think we want to see some training so that we are comfortable and confident that when an arbitrator comes into this situation, when the fact finder, the conciliator enters the hearing, they understand the language that would be used to support the negotiations proposals. And there's some sort of opportunity for us to engage in that, but I will be candid that sitting in a room where we're negotiating specific language about a collective bargaining agreement it's a difficult situation to say, now let's all level set on the racial impact of systemic issues and how that looks, and let's make sure we all have the same vocabulary so we can talk about wage increases. It would be an unusual forum for that level of training. At the same time, it can certainly be weaved throughout the proposals to say, here's why this matters. So for example, one of the things I mentioned that insurance was a big deal. It was a priority for the city last time. The city's position was that its insurance programs were out of date and that they were not up to market, and that taxpayers, citizens were looking and saying, this, what a city employee is receiving in benefits is way better than what I'm receiving from my employer as far as benefits go. Well, so what we were able to do is put together that theme throughout many proposals and why it's important, and use that as kind of a marker for where we need change. And that's where I would think, and what I hear you saying is you want us to look at it that way going into this round, but not with insurance, obviously, but with an understanding of the racial impact or the impact on particular races based on what policies are enforced throughout time.
Yeah, because I think what tends to happen is these types of discussions, racial equity and those conversations around race are siloed into something else, and yet this permeates through everything in every aspect of the negotiation. And it is critical for people to be equipped with the vocabulary about this, but also the history and understanding of the impacts of these policies. And I think at the end of the day, as you mentioned before, obviously it's hard to have these conversations in the moment. But again, I think that is how we start moving in the direction of where we need to be, because what has been happening on the whole has not been working on the whole, right? So then there are aspects that might be okay, but on the whole, we still are running into these issues. And especially when it comes to the major issue that brings up a lot of the discussions that we're having right now has to do with this type of impact, disparate impact because of racism and the disparities that we see within our police department and also within the city as a whole. So I just think I encourage that to be more front and center as we continue these negotiations moving forward.
Understood. Excellent.
Hey, Jenny, and is a part of that difficulty for maybe even the role the fact finder might play, is it that even though I'll even say fundamentally know there's probably a disparate impact on communities of color, that becomes difficult to document and prove? Is that a part of the challenge here on trying to push for some of these things front and center?
Absolutely, it is. And there's, because whenever you're going into a hearing, an evidentiary based hearing, people are going to look for objective, documented proof that there is this particular problem. So that's why we looked to last time a lot of that outside research and articles and assessments that had been made to say, look, there's a pretty clear understanding in our community that there are some problems, and therefore we want to see these changes. We think it's important. But looking at the type of evidentiary proof that would be necessary in this sort of hearing to say, and therefore we're going to have, here's a concern that's been identified, even an analysis that has been done about the impact of particular policies within CPD. Like, we can see that, but then tying it back to the specific contract language is not always a very easy connection. Campaign Zero did do some work along that route and had identified and specifically looked at the city's collective bargaining agreement with the FOP and did help make some of those connections, saying, look, generally we see that there's a problem if officers are provided greater access to the evidence that might be centered to an investigation than somebody else. Then they looked at the collective bargaining agreement and said, hey, the city of Columbus, as well as many other cities, have language that makes this easier for officers than we think is ideal. So that very specific connection to contract language in the work that they did was valuable to us. It's not always quite that easy. And so a lot of the changes that I know that you all are looking at in particular, we can maybe as a group agree that there's a change that needs to be made. It's not always easy for an arbitrator or fact finder to look and say, oh, I see the connection between this concern and this specific 3-word phrase in the collective bargaining agreement with the FOP. That's helpful. All right, so last time we did get a fact finder's report. It was not rejected, which means that it was deemed accepted by both the Lodge and City Council, and therefore it was incorporated into the collective bargaining agreement. So I'd like to talk about some of those changes because we've talked already about the fact that we went through 22 rounds bargaining sessions. We also had additional conversations outside bargaining sessions. We've talked about all the preparation for the 6 days of hearing. And I'd like to talk to you a little bit about what the city's goals were last time and the changes that were made. Again, not assuming that this is going to be exactly the same, but to give you a sense of with the type of progress we made last time, how much time and energy and focus it required to get to that point. So in the 2017 agreement, the city had established a very, for me, daunting and also impressive list of goals. So they wanted to see improvement in the accountability and transparency as it relates to officers and their conduct, wanted to reform the citizen complaint process, remove the past practice provision and the protection that provides, wanted to make investigations fairer. And when I say fairer to citizen complainants specifically, provide the chief rather than immediate supervisors more authority over discipline, increase the length of time records that could be used for the time that records could be used for disciplinary purposes. They wanted to make responsible wage decisions because obviously the city is the steward of taxpayer funds and takes that very seriously. And then, as I said, restructure the health insurance plan to conform with the rest of the city's insurance plans. So there were, I would say last time we had the city was in a very strong economic position. COVID has changed some of that. But there were some really significant economic issues last time that had been identified as priorities as we tried to modernize the FOP's insurance plan. And so that was significant, as well as then the non-economic issues. So I'd like to share with you some of the things that we believe to have been successes. Now, keep in mind that what I'm sharing with you now is not the initial proposals that the parties came in with, right? So the city comes in with potentially a lofty goal. So, I mentioned, maybe the city wanted to eliminate the past practice provision, and that was not a reality that was met. But as we go back and forth, we have to look at, well, what is the FOP asking for? What is the city asking for? And it is, in fact, a bargaining process. They're a negotiation. So it's, I'll give you a little of this if you're going to give me a little of that. And that's the whole dance that the parties must engage in to come to an agreement, even on half the contract like we did last time. So we're looking at places where it was a goal and we made some change, albeit incremental. And this year some of these things ended up being really critically important to work that the city had to do over the last, 4-ish months. So one, at the time that we went to bargaining, citizen complaints were only able to be filed 60 days, up to 60 days after the underlying incident had occurred. We were able to negotiate moving that timeline from 60 days to 90 days. That extra 30 days was very valuable to us and to the city this year. We increased officer oversight, so recognizing that that had been identified by the community as unacceptable to today's standards. There was a short deadline for non-sworn division employees to file complaints alleging discrimination in the workplace. So we were able to remove it. It had been held to that 60 days. So if I was an administrative assistant within the public safety division, I would only have had 60 days to bring forward a discrimination or harassment complaint against a sworn officer. So we were able to pull that out of that 60-day timeline, which ended up being a 90-day timeline. Go ahead. Is somebody asking a question? Okay. There was language that at the end of what was that 60-day timeline, there was language that prohibited officer discipline if it took longer than, if it took longer than 90 days or 60 days to complete the investigation, an officer could not be disciplined. We were able to eliminate that language, which allows much greater flexibility when considering a citizen complaint. It allows greater time to complete that. There's still a 90-day timeline, but if that timeline's not met, it doesn't automatically mean that an officer cannot be disciplined for any misconduct there. There was an issue, and some of these are a little in the weeds, so I'll try to talk about them quickly, but there was an issue where there was contract language that said, if I'm an officer, and it went up and down the chain of command, but if I'm an officer, the person who must make the decision about any discipline that would be that I would be subjected to would be the very next level of supervision. So it'd be at the sergeant level. And it couldn't be a lieutenant. It couldn't be a deputy chief who was going to look, or commander in the middle, who was going to look and say, this is the discipline that I think is appropriate in the situation. It was the person that I worked with most closely on a day-to-day basis. And there were some situations in the past where the city said, look, we don't think that person is disinterested enough in all cases in order to issue the discipline. And so it's not right that it would be limited to only the person immediately above an individual in the chain of command. So we were able to expand that. So it's no longer the lowest level of supervision who has to issue the discipline. And then on top of that, again, with the same kind of point, it used to be that if a sergeant disciplines an officer, then if someone more senior in the chain of command, let's say a deputy chief or even the chief, would look at that the discipline that was issued to the officer and say, whoa, that's not documented corrective counseling, that's a suspension, or maybe that warrants termination. There was language built into the collective bargaining agreement that said, look, the city has to provide very specific reasons for overturning what it is that lowest level of supervision had said. And so we said, no, that's not right, because a deputy chief, a chief, people within those higher levels of the chain of command are going to have a greater view of what's been done across the city, about what's been done historically, about what it is that the director of public safety has identified as a priority when we look at disciplinary issues. So we were able to remove that burden of this that the city had to overcome previously to say, yes, maybe again, a sergeant issued a documented counseling, but the mayor, or not the mayor, I'm sorry, the chief or the deputy chief looked at it and said, no, we think really something else is appropriate. There wasn't some sort of evidentiary burden that the city would have to overcome in that arbitration over discipline. Hello? All right. So, for example, here, the decision to issue corrective disciplinary action or inaction and the level of corrective disciplinary action is subject to review by the chain of command. So we took out language that said otherwise. When we look at progress that is made, remember I talked about, and you all are fully aware of this, but that kind of give and take that is necessary when we're negotiating. So one of the things that both of the parties have to do when they're thinking about their interests at the table, they're trying to make progress, and they're also trying to ensure that things that are important to them, they don't lose rights under different language. So we're trying to move some things forward, and we're trying to, at a minimum, hold the line on other things. So when we look at a successful round of negotiations, we're thinking about not just where we were able to make changes that we had identified as priorities, but also where we were able to ensure that the FOP didn't create new or greater rights for officers in areas that the city believed would be inappropriate or undesirable. So we were able to maintain officer oversight by holding a line that the FOP had proposed to the fact finder, that they wanted to create a very specific definition for critical nature that would have allowed the city to bypass progressive discipline. And we said, no, we think that there's good language there that served the parties well so far, and we were able to ensure that no changes were made to that definition. There was a proposal to the fact finder to increase the chief's leave forfeiture option for a suspension. So currently, rather than issuing a suspension, the chief has the option under the contract to allow an employee to forfeit leave instead. So I'm going to give up the vacation time that's sitting in my vacation bank rather than actually taking a suspension. Currently, that is limited to 120 hours. The FOP advocated for that to be a suspension of up to 240 hours, which would limit the opportunities for discipline to be put in front of the public safety director. Where he has, in this circumstance, he has the ability to weigh in and issue suspensions and terminations. So we were able to kind of hold that line and ensure that there wasn't a change in what we would have, or the city would have perceived as the wrong direction in that scenario. We also, there were documented corrective counselings. This is the lowest level of discipline within the contract. Instead of that being a very short period of time, we were able to increase its length that it's available, so that it's available as a first step in the step of progressive discipline. So the amount of time that it was able to be considered was lengthened, and that helps move officers with chronic problems through the disciplinary scheme much more quickly. We also held the line in a few other areas where the FOP had proposed to allow members with suspensions of less than 120 hours to be selected for an assignment change. From the chief's perspective at the time, but that was inappropriate because it would allow officers who had been suspended to then potentially kind of move over somewhere else and not continue to learn and identify ways to be better in the assignment that they were currently holding. The FOP had proposed to increase the rights for witness officers in investigations. So there's a focused officer, there's a witness officer, and they wanted to provide greater access to records for witnesses who are being asked to share information they may have about someone else who is alleged to have engaged in misconduct. And so we were able to hold a line there and say, no, we don't think additional information needs to be shared in advance. The FOP had a proposal to narrow the scope of an investigation related to officer misconduct. They wanted to make it harder to talk to an officer about a wide array of topics, which is already very limited under the contract. They were trying to narrow that even more, and we were able to hold the line and keep the language where it was before. We were able to hold the line where the FOP had a proposal to prohibit discipline if that's scope. So if we were asking broad questions of something that needed to be narrow, the FOP proposed to prohibit discipline if that scope was exceeded. We held the line there, so we did not see a change in what the city may have perceived as the wrong direction. So all of that, when we look at it, there were all these changes where we either held things where they were at the time so we could maintain the status quo, or we were able to make these changes that were very beneficial to the city, unbeknownst to us how beneficial they would be at the time, but that would enable the city to be a little more nimble and react in a different way to allegations of officer misconduct. We also then achieved significant changes on insurance, which was that priority. So we were able to make some of these non-economic changes and achieve some progress in the right direction, but also to make changes on insurance and get that policy modernized, which was critical to the city and its bottom line. But when we think about that, when you think about what helped the city achieve its goals, the city was in a strong economic place, and the city is still, doing well. And I know we have finance who's going to talk a little bit about budgeting. The city is still doing well, but it's in a different place than it was in 2017. And so there's a different bank account for wages, for example. There's a different bank account for making changes to insurance in a way that would make sense. And a lot of times when we're looking at this give and take, keep in mind, we talked a lot now about non-economic issues, but that give and take is, we're also talking about raises for the FOP. We will also be talking about how much they're going to contribute every month to obtain insurance benefits and what their co-pays are going to look like and all of those things. We're also looking at potentially vacation balances, holiday pay, overtime opportunities, like all of those economic components are there, as well as all of these non-economic components. And so those end up being a part of that give and take too. And oftentimes where we see early on in a negotiation process, the parties are like this on non-economic issues, because we generally start with those. When we get to economics, the amount of flexibility the city has on what sort of wage increases it might offer will affect the way some of the non-economic proposals it's made are perceived. The likelihood that the FOP might say, okay, we're willing to wiggle a little there because we're going to get wage increases that look like X, Y, Z. So the city's economic circumstances also affect the ability to make change on these non-economic issues. And then what else helped us last time? We did look at comparables, and we do look at other cities. We look at, and I said, we look at the region to say where there are things where Lodge 9 for the city of Columbus might be out of whack a little bit. That's very valuable to us. And that tends to be particularly persuasive with the fact finders and conciliators. And then support from the community for making both economic and officer accountability progress. So when we looked at that insurance, one of the reasons that's a priority is because the prior mayor pulled together an economic advisory council of citizens in, I think, 2009 to establish economic priorities for the city over the next 10 years. And the city has, through multiple rounds of negotiations, looked back at that economic advisory council's report to try to meet the objectives that were set there. And so I see we looked at that and we're able to show a fact finder, look, here's priorities that were established. We've been effectively working towards these for a long period of time. We want to continue to do so. And there's certainly an opportunity on the non-economic front to look at similar recommendations and priorities that are set on kind of officer accountability and trying to move towards the goals that are set for the city in that way. Any questions before I go to the next thing?
Sorry, Jenny.
Please.
I do. Is sort of like, I guess, what are the metrics for success? Like, what allows them to say, we're doing a good job, we deserve a raise? Because I'm just thinking, like, we're probably going to have record homicides this year. That's not, like, how do you... does that factor in negotiations for you to point and say, violent crime is up, homicides are up, you're not doing a good job, so we're not going to, give you more resources?
There are no metrics along those lines established in this collective bargaining agreement. This collective bargaining agreement is only looking at kind of budget and ability to pay as compared to the FOP's proposal, and then considering that in the context of non-economic priorities as we've been discussing. I've never seen a police contract that would include those sorts of metrics, and I think you could end up in some very difficult situations where you just start imposing those. Now, it's not something I put a lot of thought into, but I would think about when we are when you see, for example, I don't know, I feel like on 60 Minutes, I saw a whole story one time, right? And they were talking about performance metrics related to speeding tickets and how identifying performance metrics related to speeding tickets had both positive and negative effects for the community that was served by officers. So I can see how there would be substantive challenges to creating something like that in a collective bargaining agreement about things that are much more critically important to the health and being of our citizens. Because I think in the end, I would posit to you that the FOP and the city share the same goal, which is we would like to not have murders in the city. We would like as few of those as possible. It's difficult to suggest that the majority of officers would think that that was okay, that the number was high. I would tell you, I think that's a hard story to win. But it would also be very difficult on a practical basis to kind of tie that any sort of raises to metrics for performance like that when we've seen it kind of fail in the speeding ticket context. But certainly, again, you guys as a working group,
Well,
I just have ideas about what I've seen in the past, and you all are able to make recommendations about what happens in the future.
Well, I think that kind of is the point. There's a question I had on this front is really around, obviously, as it relates to the 2017 agreement, but with such circumstances moving forward with something like the potential passage of the amendment and the recommendations from the civilian or from this group for civilian review board, that's going to be a big change, right, in terms of the negotiations, right? So, how do you envision some of that? And obviously, I know, you all have to kind of work through some of those things too internally, but, that will be a big change. And obviously, if status quo is kind of the way kind of things move forward, how do you expect this to be a big priority where we can actually get some wins and recognizing that you're going to have some trade-offs along the way?
Yeah.
Hey, Jenny.
Please go ahead.
And this is Mo. Just as you go into that, because I know time is moving, I do want to Kyle's question exactly, kind of level set the group on what you think there'll be some challenges or some long shots or some opportunities not even opportunities, where we might have some challenges, I think, with some current recommendations. I think it's important that the group, even in our quest to want to push for certain things, we be realistic and go in with our eyes open about what's probably possible and not possible in negotiations without knowing the outcome. But you have a body of experience. I want you to bring some of that to our consciousness, please.
Absolutely. Thank you. And I would start with, keep in mind, I mentioned the Mayor's Economic Advisory Council, as Mayor Coleman's, and how there were priorities set there that had I believe it had 10-year timeline. And over the course of time, the city has prioritized those and made very small changes that feel big if you're an employee and you believe that something might be being taken away from you. But from, if we lived in a dictatorship, the mayor would be able to say, no, tomorrow we're not going to continue making these particular contributions to retirement plan, but that's not the situation. And so instead, it's very slow, intentional steps over a period of a decade to get close to, and I haven't looked recently just to know if it was actually all of them were met, but close to what the Economic Advisory Council advised in 2009. I would anticipate, Kyle, that that this might look somewhat similar to that. But I will also share with that in the sense that there are goals set and that will take a period of time to get there. Because you're looking for significant change, and labor relations in and of itself favors the status quo. So I think there are ways to use that, and there are ways for us to prioritize that. And we certainly are going to look to, the Safety Advisory Commission's recommendations and the recommendations and goals that come out of this working group to say, here's what priorities are going to be, and we need to work towards them. However, there are significant challenges, both from the perspective of labor relations moves at a snail's pace generally. From the perspective of that give and take also generally relates to the economic circumstances of a public sector employer, and from these particular CBA provisions that can create some challenges for you all. So I wanted to run through some of these just to give you a sense, and I know time is short, so I could pontificate for a long time about a couple of these, but I'll try to be quick because but it's important that you understand that there is language in the contract that will create a significant hurdle to moving forward with some of the recommendations that you've already indicated that you believe will be priorities. So one of the places where we see a challenge to making change within CPD is Article 2.7. And Article 2.7 is past practice. And you may recall that last time we talked about past practice as something that is considered within general labor law to be something that's important. That's kind of what have the parties done in the past to fill in the gaps in the collective bargaining agreement where there isn't language that specifically relates to an issue. The arbitrator, a fact finder, a conciliator will look back and say, well, what have the parties always done in this situation before? And they'll expect a particular level of evidence to demonstrate why doing something different in this circumstance is appropriate. Why are we moving away from the status quo? So we've talked about that as a general legal concept, but then also in Article 2.7 of the collective bargaining agreement, it also says that the city cannot automatically just change past benefits and practices. And specifically, and this is language that's been in there for potentially as long as I've been alive, I'm not positive, but a long, long time. In 2.7, it says the city agrees to continue all existing practices and benefits during the term of the contract. So that means anything where you look at this agreement and there isn't something that specifically speaks to it, there still might be a reason that the city cannot move forward with it by virtue of Article 2.7. And so this can create a real barrier to change, even necessary change. And the city has attempted to change that language many times and has not been successful in doing so. And it's not one of those things, it would be very risky to take it all the way to the point of a conciliator where somebody might be making changes to the language that are detrimental to the city. Article 8 specifically talks about the officer protections during an internal investigation. And those include that we've talked a couple times now about scope. What is the scope of an investigation? That's defined in Article 8. We've talked about the rights that are afforded to a focus officer, so the person who's alleged to have engaged in misconduct, as well as to witnesses. We've also talked about who's going to conduct investigations. So there is a preference in the collective bargaining agreement for the Internal Affairs Bureau to conduct investigations. And there's a requirement that if it's an outside entity, which is under Article 9, if an outside entity is going to conduct investigations, then they still are subject to all of the rights and limitations that exist in Article 9. So that this Article 8 is going to apply currently for IAB officers. It currently applies, all of those restrictions apply for someone outside of public safety who's going to investigate. So there's language there that very specifically will create hurdles to some of what I've heard as priorities in the investigative powers front. Article 10, progressive discipline. So that's showed there's progressive discipline, and there's an assumption in a progressive discipline context that somebody will, except for in extreme circumstances, start off with a documented corrective counseling, and then they'll go to, I think we go to written reprimand next, and then you move from one step to the next step to the next step. That is something that I hear the working group talking about as, no, we think we might want to just be able to discipline differently. And that could be a challenge based on the progressive discipline. Also, when we look at who's going to issue discipline, it very specifically is saying it's going to be someone within CPD who is issuing discipline, not someone outside of CPD. So that would be a challenge in moving forward with issuing discipline. Another place where you will see some language, the grievance and arbitration procedure. I've heard some concerns about that process and that procedure and the rights that are afforded there. Article 12 has a very robust grievance and arbitration provision, and that's where discipline is able to be, for lack of a better term, kind of overruled or overturned. And so if we're moving outside of that, or if the CRB, for example, was recommended to have the opportunity to review and change discipline, there would be a potential issue both under Article 10 and under Article 12 and what that would look like. Article 14.1, pull that one up because the language I'm not as familiar with. Rules and directives. It says the city agrees that work rules and division directives shall be reduced to writing and provided to all members. And it's decided by the chief. When we think about changes to policy and rules and directives, work rules, those also will be subject to past practice. So who within the division has provided, drafted directives, and who has the authority to put them through, and who has the authority to enforce them. Everything that's ever been done is potentially subject to that past practice language. We've talked a little bit about hiring. Articles 11 and 15 cover both hiring and promotion. So if you're thinking about a role in potentially hiring or promoting individuals within the collective bargaining agreement, that there's language that specifically talks about how that's going to be done. So changes would need to be made there. Article 19.4 is also an interesting one, and one I want to make sure you're aware of. And that specifically says, let's pull it up, that there are restrictions on the city's ability to contract out or civilianize law enforcement duties. So if an officer or a member of the bargaining unit had consistently done certain law enforcement duties, which is undefined, which means there's a chance that an arbitrator would look at past practice to define it, that cannot just be automatically contracted out. There's some procedures that need to be gone through under 19.4. And there are also some challenges to, then that is subject to the arbitration procedure if the parties don't agree. So to the extent that the CRB is considering investigations, there's not only the investigation article that could be a challenge, we'd also have to consider the effect of does that amount to civilianization of law enforcement duties? And to the extent that it does, if it's work that's consistently been done by members of the bargaining unit in the past, then we could anticipate an argument that that was inappropriate and that it would be difficult to negotiate that away. And then finally, there's midterm bargaining, which just means any changes that are made when the parties are not currently at negotiations still end up having to be negotiated, even if it's 2 years into a current collective bargaining agreement. So food for thought for you all, and I'm happy to engage in any conversation, thinking about what powers are critical for the CRB to have. What powers are negotiable for the CRB to have? Where do you have, for example, an end goal that you want to work toward over a period of time as compared to an initial step that maybe you would be acceptable as we move toward a stronger CRB? Thinking about, again, which functions the CRB needs right now, which functions maybe an initial CRB doesn't need, but we anticipate it might need long-term. And thinking about what economic and political considerations might influence your priorities. So for example, I've talked a lot about that give and take with economics. When you're thinking about this is a change that's critical to us, it's also important to think about, is that something where you might suggest a reallocation of funds in order to achieve that change? So it's really critical that the CRB is responsible for investigations, and we would be okay with the city allocating dollars to ensure that that change comes about. There's all of that kind of give and take would be something I would encourage you all to think about.
Could you talk about the interplay between what's in the charter, the city charter, and what's in the collective bargaining agreement? So does one trump the other?
Is Laura on?
She is.
All right, Laura, it's your turn.
So the city charter, while it does spell out, essentially it acts as the constitution for the city of Columbus, is the easiest way to kind of think of the city charter. And it does set forth the framework. Unfortunately, the case law and the statutes of the revised code indicate that even a provision in the city charter will not trump a collective bargaining agreement. Now, what the city charter can do is set forth what the intention is of the city. And certainly when we have something on the ballot right now, it can certainly, going into a negotiation, indicate what citizens of the city of Columbus want from their division of police. But in terms of being able to legally override a provision of the collective bargaining agreement, it cannot, particularly if it is a matter of mandatory bargaining.
Thank you.
I have one. Sorry, I'm trying to find my notes real quick. I had a question about sort of taking us back to the beginning, like what is like the definition of negotiating in good faith, and sort of like what are the cases that set the precedent for this definition? And have you all ever argued that the FOP is not coming to the table in good faith?
That's a good question. So negotiating in good faith, remember that part of it is coming to the table at appropriate times and inappropriate. So we need to come to agreement on locations and times and number of times we're going to come together. We're going to come forward with proposals that are intentional, like it's essentially to kind of move away from a game playing scenario, but we're going to come forward and we're going to make a proposal, and we're going to, if we back off of that proposal, it's difficult for us to then zoom forward again, right? Like they want us, when you're looking at good faith negotiations, you always want to be making progress towards a goal. And any reversal, of course, during negotiations is an opportunity for somebody to argue that you were not bargaining in good faith. Generally, in the cases where you see somebody making an argument that a party was not bargaining in good faith, it's they refused to talk to us. they didn't make themselves available. So we would be in negotiations and they disappear for 6 months, and we're trying to get to the table and they're not. That might be an argument that it's not good faith negotiations. To the extent that the parties have, again, we've kind of maybe moved from it, and everybody has their initial standpoint, and we've moved like this. If the FOP were to then, go back and say, never mind, we want to start all the way over again, we've gone to a new position, that might be an argument that they were not negotiating in good faith. At the same time, it might be an argument that circumstances changed and they needed to change their priorities, which is something that could happen to us as well. I don't know if the city has ever filed an unfair labor practice charge with the FOP against the FOP. I believe that it did many years ago, but I would have to look at that to verify for you, Jasmine. I'll tell you that the goal is, for both parties, our goal is to come in good faith, meet at appropriate times, make it a priority on both sides, and ensure that we are moving negotiations forward as it's not a team because we're at odds, but we do have a common goal of reaching an agreement, so that we're moving towards an agreement, or we're moving towards fact finding that's going to give us recommendations for an agreement, but that we're always kind of moving forward. And it would be unusual if that were different this time.
I'm just thinking, if over the last 10 contract negotiations, they have never once accepted any recommendations around discipline. Like, can you say that they were not negotiating in good faith if every time we say that we want to hold police officers accountable, they just say no?
Well, first, I would tell you we did make changes in discipline during the last round of negotiations, so it's not.
But I thought that was the fact finder making the decision, not the actual police.
So that's a fair point. The fact finder makes the recommendation. The FOP did not reject it, so it was deemed accepted. And you wouldn't use an argument that somebody was not negotiating in good faith because we ended up at fact finding. There's an assumption that parties will sometimes, and maybe all the time, end up in fact finding, and going through the fact finding process or even to the conciliation process is not a basis for arguing that the other party isn't bargaining in good faith. The parties, as much as we have to bargain in good faith, we're also allowed to feel very strongly about our positions. We don't have to move off of positions that we don't want to move off of, but we always have to keep in mind that a fact finder might make a recommendation against us, and with safety services, a conciliator might decide the entire opposite of what we want. So we're always trying to, you can take a hard stance, but in the end, that stance can only be so hard as in the end, that you're willing to risk the other party's language being put into the agreement. So that's really the protection against taking too hard of a stand, is the conciliation process, because you could really end up in an uncomfortable position if you took too much risk to get to that point and have a conciliator look at you and say, no, instead of allowing greater flexibility about who conducts investigations, we're going to put greater restrictions on it. And that would be the risk at that point.
All right, we can take about one more question on this, and I'm going to get into the city budget piece, or public safety budget piece of this, but certainly questions are still allowable. Feel free to submit those to us or Matt, and we'll certainly facilitate getting you some answers if you have questions for Jenny or Laura after today. Any last questions?
Yeah, I have a last question real quick.
Sure.
Yeah, so Ms. Edwards, I had a quick question. So I wanted to ask about are there any provisions in the CBA to kind of force the FOP to come to the table quicker as far as agreeing to some demands or amendments? I know you had mentioned that, the city can always provide a financial incentive to kind of bring them to the table, but is there anything else that's quicker that the city could do potentially to kind of bring them to the table and have them agree to the things much quicker?
There's nothing in the collective bargaining agreement that talks about the pace of negotiations or how long the parties have to reach agreement. So there's nothing in here that would say, if we're not in agreement, for example, we're going to move more quickly to fact finding. And there's nothing that would necessarily be an incentive built into the collective bargaining agreement that would naturally encourage the FOP, or for that matter, the city, to agree to something in a more quick manner than the process naturally kind of plays out.
All right. Jenny, last thing I'll ask you to recap then is just the timeline. We've been talking about the next round of negotiations. Talk about when that process is expected to at least begin. I know we don't know exactly when it'll end.
Sure. So the FOP has already demanded bargaining. So they have put forward the notice to negotiate. And at this point, it will begin at the time that the parties are able to start scheduling negotiation sessions. I believe that at this point, I know that the FOP has also made several information requests to the city asking for different types of data, generally focused on economic data, and that's a very common part of the process. So we've seen those information requests. We don't have an initial date set. But once we do, then we'll schedule them on, a regular basis that works for both parties. I would anticipate that we're looking at early to mid-November, but that's literally just me guessing, and there might have already been conversations about that I'm unaware of. So I think we're at least looking at a few weeks out, and potentially I would say as many as 4 to 6 weeks before we sit down with them for the first time.
Got it. So thank you, Jenny, and Alexa. You've been working on it well, just for level setting the group. I think part of what we wanted you to understand is there are a number of factors obviously going into the negotiation, both strategy and process. Hopefully you understand that with a bit more specificity now in terms of what that process will be. The other thing that I actually asked for on your behalf is that, that Jenny be really candid with you about what were going to be some long shots in terms of the recommendations we are making. has nothing to do with if they are relevant and should be pushed for. I think their position is they will negotiate in good faith on all of the things that you're asking for. I think it's also important that we recognize what a battle that some of these potentially can be. And that is the work, right? That is what negotiation really is. And so part of what today was about is giving you some sense of what that will be. I imagine that this will be an ongoing conversation in a lot of different circles about some of these particular pieces, and we will continue to, as we refine the recommendations for the CRB, be constantly thinking about then what that means from a strategy perspective. I say we, I'm not at that table, but the city and their team will be thinking about what the implications for that are for the negotiation strategy and process. So I did want to make sure we level set that with the group before we leave and go to this other conversation. So certainly not done with it. A lot more to flesh out the specifics of, but hopefully that gives you a sense of where the process, how the process will unfold and what's ahead of us in that process. The more immediate, so that's kind of the long term, right? Recognizing that there may be some things we're able to accomplish pretty immediately, and the negotiation process and some other things may take us down the negotiation road for the short term, or in some cases even the long term. I think we need to be prepared for that, and at the same time continue to push for things. More immediately, though, we are in a budget planning season for the city. We recognize that the public safety budget is a significant piece of how public dollars are spent, and there may be opportunities. I know that our elected leaders and the administration are looking forward to hearing from the community around how perhaps to think about priorities from that group. So we've asked Josh Hoppins from City Finance to kind of overview the city public safety budget. We'll do that quickly, give you a sense of kind of the size, scope, and elements therein. And then we want to open a conversation about how you as representative of the community could lift up some maybe either priorities within that budget or some ways to think about spending those dollars differently in the best interest of our community. So Josh, I'm going to turn it over to you, and then I'll come back at the end of your presentation and we'll have a conversation about it.
Sounds good. Hey, everybody. My name is Josh Hopping. I am with the City Finance Department. I work as a budget analyst, which means I just work with other city departments to develop their annual budget and then kind of monitor and manage that budget as we move throughout the year. So I'm going to try and share my screen. Mo, can you guys see that PowerPoint?
Yep. Yeah, we got you.
Perfect. Perfect. So very quickly, we're going to start from the 30,000-foot view and kind of peel each layer back from there. The safety department is broken out into 4 different divisions. The director's office is its own division. They're responsible for the overall coordination of the department. You've got support services, which is responsible for a variety of functions from the oversight and support of our communications technology to the regulation of various facets of commerce within the city. So think about things like alarm permits, short-term rental permits, inspections of gas pumps, things like that. That's that group working behind the scenes on those items. Police and fire are pretty self-explanatory, and they both have their own various bureaus broken out within each one of those divisions. So moving along to the budget, I wanted to start at the high level with the city's overall operating budget of approximately $2 billion for 2020. I have the general fund highlighted there at the top because that's where the majority of safety's funding is going to come from. And I'll go ahead and dig a little further into the general fund. So in 2020, the city's general fund was approximately $970 million. And this is basically the fund that supports all of our basic city services and kind of serves as a catch-all for all of those city services that don't fall into one of those other 3 specialty funds that I had listed on the last page. As you can see, public safety represents approximately 67% of the general fund budget, coming in at over $647 million for 2020. Again, one more layer back, you can see here how The Department of Public Safety's budget is broken out among those various divisions. Probably unsurprisingly, the lion's share of that budget goes to police and fire, with all but $16 million going to those two divisions. This is really due to the labor-intensive nature of public safety work and just the sheer number of personnel that are required for a city the size of Columbus. I'm going to kind of highlight that on the next slide as we dive into their major expense categories. But I will say that internal services, I didn't talk about much on the last slide. They're going to play a major role here, and that's where the city is kind of, one city might bill another city department for services rendered. I know that sounds kind of funky, but again, you're going to see that kind of play out on the next slide. The caveat at the bottom is just to note that I did say the majority of public safety's funding comes from the general fund. Just a small portion, it's about $1.6 million, comes from the city's E911 fund, and we use that to partially pay for the salaries and benefits of communication techs in police and support services. So moving into these major expense categories, we can pretty much classify most city spending into one of these four buckets. Personnel is exactly what it sounds like. These are going to be your all-in costs of city personnel, which includes both their wages and benefits. Your supplies category is going to cover everything from your standard office supplies to testing kits that they use over in the crime lab. The next bucket, professional services, is going to account, again, for a wide range of different services and contracts that the city executes with outside vendors. We're talking everything from fire's EMS billing contract to various hardware and software support contracts that we have, such as the body-worn camera system in police. I did mention earlier those internal services. When you're looking at the overall bucket of professional services, just about half of that are funds that we add in on the back end to account for those services, again, that one city department is billing to another for services rendered. One good example there is going to be bills that public safety will get from the fleet management department, and that's for the fuel and the upkeep for the massive fleet of patrol cars and fire trucks and EMS vehicles that we have on the streets. And then finally, the other and capital bucket is going to account for petty cash claims and refunds within safety's divisions. So, again, very personnel heavy on this budget. Almost 93% of safety's budget is dedicated to personnel, and that supports over 4,000 full-time police officers, firefighters, and civilian staff, as well as over 100 additional part-time staff who help support their operations. I apologize if I moved too quickly. I know we're a little bit behind on time, but I believe, that is my last slide. So Mo, I guess I'll throw it back to you.
Thanks, Josh. And so just general questions before we open up the conversations about, the big picture here. I want you to become public safety budget experts. But if there are questions you might have that might help us to inform our next conversation around priorities within the budget and maybe some suggestions about how we think about those things differently, any thoughts there from the work group?
Has there been a suggested hiring freeze?
So when the pandemic set in earlier this year, we moved to a hiring freeze almost immediately. So, any position that wasn't directly tied to COVID relief, those hiring requests were held within the finance department, until we could watch this all kind of play out and see where the pieces fell financially.
Josh, well, this is Stephanie Hightower. For the personnel budgets for fire and police, does that include, I'm going to assume that doesn't include the contractual raises that come with that. Am I correct?
I'm sorry, the contractual, I think I missed that piece.
The increases, the increases in the future.
So, Yeah, in the process of budget development, I've got to work with what I know at the time. So it will include whatever wage increases are built into the current contract for the following year. Does that answer your question?
Yes, sir. That's what I needed to know. Yes, sir. Thanks.
You're welcome.
Any other questions directly for Josh before we talk about just your priorities within these budgets or suggestions therein? Any questions about the framework here? Okay.
Hey, Mo, can I clarify one thing on the wages? Hi, Josh. So the current, I believe, and Josh, correct me if I'm wrong, that there's no current budget related to a wage increase, for example, for 2021, because we have not met to talk about what that wage increase would look like for 2021, right? So
Absolutely
you're assuming
correct.
status quo for 2021 at this point in time.
Exactly.
Thanks.
Interesting. Okay. All right. So with that as a backdrop, thanks, Josh, for that. I'm going to throw a question up on the screen from here. I want to basically move the conversation to a lot of money, right? Obviously, you know, well over $1 million in terms of even just this part. I think we talked about $1 billion, and almost $2 billion in terms of total spending for the city, but 67% of that, I believe, represented in this public safety budget. So a lot of public resources going into what we know as public safety. And so while some of the things we're pushing for and you're asking for may be longer term, and some things, you know, we can't take salaries away from people who are critical for public safety necessarily, but we can think differently about how perhaps dollars are spent across the city. Are there some efficiencies we can gain? Are there some ways in which we can think about budget differently? And so really, this conversation was much more about allowing you to kind of weigh into, you know, how would you prioritize things differently in the budget, or how would you prioritize the budget in general? So it's very much an open forum. What we would do with these ideas is allow the city to vet them, think about them in the context of current operations, what obligations might have already been made contractually, and then in other areas there may be some wiggle room to think about things a bit differently. But I do know the administration and leaders are looking at how perhaps to think about the budget a bit differently moving forward. And so any thoughts come to mind there, opportunities you see in terms of utilization of these public dollars differently? The floor is open for those general comments. Josh, if you will stop sharing, I'm going to throw my screen back up, please. Thank you. Thoughts from the work group? Should we prioritize elements within the budget to better meet the needs of the folks you are representing and talking to each and every day? Are there some opportunities here?
I'll go. I think that we know that punishment is not sort of the solution, right? Like fixing poverty is the solution. And so I would like to see our budget reflect a more modern prevention-based model than a sort of after the fact, we have people on the streets to round folks up type thing. I would also like to see sort of like on the ground community ambassadors, but we can't pay them. We have to pay them according to the skills that they bring to the table. And there are people that can step in between people that have a gun and defuse a situation, and that deserves to be paid well. So I just think that we need to keep in mind when we hire people for the sort of these community roles that they are experts and that they deserve to be compensated as such.
Okay. I heard two things there. investing in community liaisons and making sure they are paid in a way that's commensurate with the role we're asking them to play and the skill set they're bringing to perhaps be a complement to actual police force. And I also heard you talk about greater investment in prevention as the priority versus the actually policing of the community in a reactive way. Other thoughts from the group in terms of priorities for the budget?
I'd like to understand from the people who do the bargaining whether in general they see the advocacy for some of the things we want that are non-economic considerations, like the review board and its implementation and the procedures and policies associated with it, is that almost entirely a negotiation for dollars? Or are you sometimes bargaining non-economic versus other non-economic terms?
That's a great question.
Any thoughts on that?
Yeah. So we are also bargaining non-economic versus non-economic. Where I see there being a challenge going forward is we are, and that's actually, I'm kind of back up and use last time as an example. We remember I talked about there were a bunch of places where the city held the line and on particular proposals that the FOP made, we were in some sense bargaining the non-economic changes that we wanted to make or the city wanted to make as compared to holding the line on non-economic changes that the FOP was trying to make. So if we want to see, ideally the city would be in a position where we say, we want to make this change, like we'd be in a better spot if it was just, okay, great, we'll give it to you. But really what we're doing is we're saying, we want to make this change in this direction. And oftentimes the FOP, because its job is to protect employees in the way that it views is appropriate, it's saying, well, we want to make a change in this direction. So that's how we end up with some of those hold the line kind of items, is we're trying to make a non-economic change, as are they. And the success is that we didn't see rights and privileges that were important to the city be taken away.
Thanks, Jamie.
Sure.
Other thoughts about budget priorities particularly within the public safety line? Would you like to see different, perhaps what they explore, better use of dollars for any of those type items?
This is Jonathan. Although I agree with Jasmine that there needs to probably be less enforcement-oriented action, I think there has to be a balance stricken. But sometimes that is something you have to do, right? And I would want to comment on this question. I think it's an excellent question, but I feel like we don't have enough context to answer the details of this. I mean, we have the totals of the budget, but especially in light of the challenges we face in collective bargaining, it's hard to make this sort of determination from my view.
Well, and I think just to not complicate it, we didn't want you to get too far into it, because the question still will be, and this won't be the last time you probably hear us asking this question in the broader community, but I think the question here really is, you've got public dollars being spent. We want to hear about priorities. We can work with the professionals like Josh to try to find the money to do it. The question is, what are we finding money for? So I probably ask you to think about it in that way. Like, what would be your list of priorities within the budget? And knowing that we have to maintain law and order, knowing that we want to have a certain amount of prevention, knowing that we've got to clothe and make sure officers are on the street, those things. But there can be a number of other line items that might have some flexibility. What would you do differently, or even more of? Could be the other way to think about it within that, and then we can bring you back some specific proposals as the budget kind of unfolds.
Right. I guess in that light, I would say training would be a priority. Sort of different aspects of, diversity, inclusion, those sorts of trainings. De-escalation training. I know they do some of that, but something along those lines. should be prioritized pretty highly, both in the pre-service academy and in the in-service training that they do.
Right.
And then just community relations, how the police officers interact with the community and the opportunities to do that. Those would be like the top 3 priorities in my mind.
Good. Thanks, Jonathan.
I'd like to echo the priority of training. There's a lot in the Safety Commission report around training, and a number of those go, I think, toward the de-escalation, especially with youth, as well as then the sort of proactive as opposed to reactive punitive engagement.
Absolutely. Other thoughts? One. All right. Well, certainly that's not a closed conversation, but we did want to at least open up the conversation today. If you have thoughts around this, or as you talk with your constituencies about better ways to utilize the dollars that are a part of the public safety budget, but really across the city in many ways to further our public safety goals, we certainly want to continue to hear that. And I know our city leaders want to hear more from your groups around how better to prioritize those dollars as they are taxpayer funds, and we want them to be utilized in a way that furthers the entire community's goals, in addition to the bargaining process, which we know is also about to commence as well. So wanted to invite that opportunity and know that it's not a closed conversation, but we did want to at least allow this group to weigh in formally on it if you had thoughts about it, and if not, certainly feel free to share that at a later time if those ideas do emerge from you. I think that will get us toward the end of our agenda, but we do have a couple minutes. I'll open the floor for any additional general thoughts or comments about the work of the Civilian Review Board work group or related issues therein. Any general comments or thoughts from the work group?
Hey, Mo, I have a question, if you can hear me.
Yes, sir.
Yeah, it's Anthony. Hey, I know the Internal Affairs Bureau has a significant number of sergeants, and in thinking of budget, because I do need to process this a little longer, is there a possibility if we are going to have investigators to reduce the size of the Internal Affairs Bureau and redirect those funds in terms of salary to the independent investigators?
Certainly, I don't have the answer to the question, but it is certainly noted, and I think it's a part of what we will be thinking about. Go ahead.
Can he repeat that, please?
Yeah,
Mr. Wilson,
I know. Yeah, I know the group had asked about having independent investigators, right? Either in the IG's office or as part of the CRB. The Internal Affairs Bureau has a significant number of sergeants. So I'm just wondering if that bureau could be reduced and the funding directed towards the salaries of those internal affairs sergeants would then go towards the independent investigators.
Oh, it's interesting though, because the matrix report, which is on the new dashboard that we released this week, calls for the addition of 17 additional sergeants. So if anything, I think that those sergeants would be spread out through the division, because the span of control of sergeants right now is they're spread too thin. So we've got all these competing reports, and so that's interesting though, because if we do have the ability to have more sergeants because of the Civilian Review Board and the Inspector General, we'll have a use for those sergeants. But that is a good point. Thank you.
Could you eliminate those sergeant positions and make them the civilian positions for the independent investigators? You
Eliminate
may save money
the sergeants.
that way. Positions. So, or move those positions to patrol. What I'm looking at is if you're going to add additional 17 sergeants, that's a pretty big penny for the budget. Could those investigative positions be used in a civilianized role with the CRB or the IG's office? Does that make sense?
Does that get us
I can
into
email it.
contract? I think it was 13 point something. Does that get us into that
Yeah.
challenge?
You would certainly, it's something the city could consider, and from a budgetary standpoint, I would always defer to Josh. At the same time, there would be potential contract issues with that. And so it wouldn't be something that could be done unilaterally and quickly.
Right. And the fact is, if we had the ability to move sergeants from somewhere to put them out to fill the matrix need without spending money in the budget, that was, that's where we would have to go, because we absolutely don't have the budget capacity to hire 17 sergeants right now.
Got it. Other general comments or thoughts? These last couple minutes. Okay. Hearing no further, we'll get ready to close it here. A couple process notes. So we're at the point in the process where we really use the last meeting to level set your thinking. Great conversation there. And so we have the skeleton of recommendations around some things, everything from structure to anticipated authorities you'd like the CRB to have. There still are a number of question marks. And so I say this in the context of the next meeting date. We are going to be putting some distance between this meeting and the next time we meet. It'll probably be about a month out, and that will not be a period without communication. But our intent is to be able to really spend time taking what you've already given us and bringing you back a lot more concrete of a recommendation. And so folks from our Baker team, folks from our city attorney's office, the leadership on the project are all coming together to really start to basically turn your feedback up to this point into a recommendation for you to react to. And so we're hoping to have something concrete for you to see in writing by the end of the month. And then we would follow that up with a meeting early in November to vet that recommendation with a little more specificity, given some of the conversations we've had. In some instances, we have good direction. In other instances, you've all given us some direction, and there'll be time to make some decisions about your recommendation. And so we may ask you to put some things to a vote or ask you to endorse some of the directions you've had. So at this point, we kind of need to go offline, do some additional work, get this to a point where it can start to look like a formal structure for the CRB and IG office. And at the same time, once that process is done, then we'll need to start moving that toward the legislative process toward the end of the year. And that's where Laura and her folks pick up the real work of making this something that the city can actually implement from a policy perspective. So I wanted you to know that we don't have a meeting date yet. I can tell you they'll probably be the first or second week in November by the time we formally reconvene. But I also will tell you, you'll be asked to look at a more formal structured recommendation based on your feedback prior to that date, and perhaps get some feedback in a different way. And we are thinking about several ways in which to do that. So with that said, Matt, I'll turn it over to you to say anything I didn't say or add an additional context to what's ahead of us, and then we'll get ready to close from there.
Thanks, Mo. I think you covered it. As you mentioned, I think we're looking at November 12th. I haven't had that confirmed yet, but if everyone can hold that date for us for right now, we'd appreciate it.
I didn't want to say it, but November 12th, as you did, try to put a hold on that for us. And we've got some other calendars to make sure we check through, but that's our tentative date at this point. And obviously we'll get that out to you as soon as we can confirm it. Any final, Kate, anything from you?
No, sir. Thank you so much, everybody, for coming out again.
All right. All right. With that, folks, hearing no other comments, we'll get ready to adjourn here today. Look forward to engaging with you later in the month, and look forward to seeing you probably on November 12th date to be confirmed. Thanks for your time tonight, and we'll see you soon.